Singh. Next legal. This session will be taken up by Mr. Singh, who is a member of Honorable Supreme Court of India and fellow member of Institute of Company Secretary of India. He has secured doctorate in law. Mr. Singh is an advocate by profession and practicing at Honorable Supreme Court of India. He has extensive experience of more than 20 years in litigation. Mr. Singh is a founder and partner of an international law firm, Linux Legal. Nux Legal has been operating as a corporate law firm in retail concept and currently handling litigation matters in more than 500 districts in India and abroad. Mr. Singh is also running an NGO with the name and style Vidya Vijay Foundation and serving the poor and needy people for upliftment of their education, social and living standard. The name Vidya and Vijay came from the name of the parents of Mr. Singh. The first word is the name of his mother, Mrs. Vidyadhari Devi, and father, Dr. Vijay Narayan Singh. Mr. Singh is the visiting faculty of IIM, ICSI, ICAI, and various other law colleges and business schools in India. Mr. Singh is also socially and politically active and contested the election of Legislative Assembly at Delhi twice. Now, I would like to call upon Dr. Nityanand Singh to proceed with the session and embark all of us upon this topic with his knowledge and wisdom.
Thank you, Ms. Yaska, for such a wonderful introduction. Certainly today we have a session, Bharatiya Nagarik Suraksha Sanhita 2023. We will go ahead with all those that there, because this is the new act came into the force with effect from 1st day of July 2024. So therefore, of course, it is beneficial to all the fraternity members, advocates, company secretary, and chartered accountant for all of us, because it's going to be implemented from it's already been implemented from 1st July 2024. So of course, it is new for all. So certainly, I will try to cover and I will try my level best to explain the new provisions introduced through this Bharatiya BNSS. Bharatiya Nagarik Suraksha Sanhita, a comprehensive analysis. So I will try to analyze all the provisions, new provisions inserted, and what is the changes takes place. So first of all, I would like to know, I will explain Bharatiya Nagarik Suraksha Sanhita. The earlier it is replaced. This act replaces the Code of Criminal Procedure 1973. So I will go to a little bit about the background, not in detail. The earlier act is a CRPC 1973, the Code of Criminal Procedure, and before the Code of Criminal Procedure 1973, there was another act that was a CR 1861. 1861 act was replaced by Code of Criminal Procedure 1973, and Code of Criminal Procedure 1973 is replaced by the Bharatiya Nagarik Suraksha Sanhita 2023. This is a little bit about the 12th December 2023. This bill was introduced in the Lok Sabha. 20th December 2023, bill was passed in the Lok Sabha, and 21st December 2023, the bill was passed in the Rajya Sabha. And 25th December 2023, the President assent, and it was also published on the official gazette on the same day. I would also like to explain that the day in which it has been notified in the official gazette, it has been become the act. Earlier, unless and until it got the assent of the President, up to that date, it is bill. But once it got the assent of the President and published in the official gazette, then it is become an act. So what is the difference between bill and act? You can understand. There are the certain provisions, new provisions came into the force by BNSS. So I will discuss in detail. Why there was a certain needs? Because there are the certain changes takes place due to changes in the society, due to changes in the environment. So therefore, we also need to change in the act itself. So these all are the background introduction, why this act was required, why it is required a new act, and all those things when the presentation came, when it was introduced in the parliament, when it was introduced in the Rajya Sabha, Lok Sabha, and Assembly. All those, this is the background. This is not very much important, but very much important to understand what is the new changes takes place. What is the basic purpose to came this BNSS? This is that there are the certain new changes, time-bound process, investigation, trial and investigation. There are the certain time-bound process. It has to be completed within time. Citizen-centric, supply of the FIR, copy of the progress of the investigations. Trial, summary trial, mandatory for petty offences, accused examination, appearance or hearing through video conferencing, multi-step system. There is a new concept came into this BNSS, that is through video conferencing, hearing through the video conferencing. Even though there was this concept came during the Corona period. There is a video but this provision was not earlier in the Code of Criminal Procedure because there was no need to go through the video conferencing process. Just let me. I will share again. Just there are certain issues, technical issues. I will share the screen again. Is there any?
Yes. Nitya, it was okay before. There's no problem. You can continue.
Yes.
सर ठीक है आप कंटिन्यू.
Yes. Modernization, use of the technology and forensic sciences in the investigations and summons. These new technology introduced in the BNSS. Overall overview of the changes. What the changes takes place? Earlier form of the summons. The section 61 CRPC was deals with the summons, in which form summons has to be issued to the accused persons. Now 61 replaces section 63. Section 63 of the BNSS talks about the how in which forms the summons has to be issued. These are changes in the sections. So overall, we are discussing with the changes. What are the changes takes place? Forms of the warrant of arrest and duration, because these are the forms of the very important forms, and we have to understand how summons has been issued earlier in the forms. Section 61 deals with that. Now it is section 63. Form of the warrant of arrest and durations. It was dealt with earlier section 70. Now it is 72. Proclamation for person absconding. It was under section 82 of the CRPC, but now it is 84 of the BNSS. Order for maintaining of the wives, children, and parents. 125 CRPC deals with the maintenance of the wives, children, and parents. Now it deals with the section 144. Information in cognizable cases and non-cognizable cases. 154 to 155, and here 173 to 174. These are the changes in the sections. Examination of the witnesses by the police under section 161 CF, because there was some Statement was recorded by the police under section 161 CRPC. Now it has to be recorded under section 180 CRPC. These are the only changes in the section. Almost contents are the same. So whatever the changes take place, we will discuss later on. But we are here discussing only the section changes. Recording of confession and statement. Earlier it was under 164. The magistrate was recording the statement. Now it is under section 173. Report of the police officer on completion of the investigation 173. Now it is under section 193. Cognizable offense by the magistrate 190. This is the one now 210. Reference to the High Court section 395, and now it is 436. In what cases bail has to be taken? 436. Earlier it was 436 to 439 deals with the bail. Now 478 to 483 deals with the bail. Earlier we have moved an application for the bail before the Metropolitan Magistrate under section 437 or Judicial Magistrate first class. Now we can move an application under section 480. Direction for grant of bail to person apprehended arrest. The anticipatory bail was moved under section 438 earlier. Now it is 482. And special power of the High Court or Court of the Session for grant of the bail under section 439. Now it is 483. So these are the section changes. The changes take place. Now we will discuss what the new sections in the BNS has been inserted, which was not available with the Code of Criminal Procedure. This section is entirely a new section introduced in the BNSS. Because we have also discussed with the BNS, Bharatiya Nagarik Sanhita, and in which there is a community service as well. Community service has been defined also there. So here is also a new concept of the community services introduced in the BNSS and BNS also. If there is a punishment in the PT offences, there are the certain punishments have been awarded by the Honorable Court. Then you have to provide certain community services. Earlier it was also, because once I was in the High Court, then the Honorable High Court passed an order that you have to provide the services 15 days or 20 days in the Gurudwara. Continuously, that is free. Of course, once this is a punishment, then you have to do the work free of cost. There is no remuneration, everything, you will not get anything, but you have to do service, and you have to do service not voluntarily but by force. So this is the community service. Once you are doing some petty offences, then you have to do certain community services. It is a discretionary power of the court vested with the court that they can impose some sort of punishment in the form of the community service. Community service punishments were introduced as a new form of the punishment aimed at benefiting the community through unpaid work by the offender. Section 23 grants power to first-class magistrate and second-class magistrate, allows these magistrates to order community services in the form of the punishment. Explanation under Section 23, community service should be beneficial to the community and specify that the work must be performed without any remuneration. This Section 23 of the BNSS, community service should be beneficial to the community and specify that the work must be performed without, of course, once it is a punishment, then it should be without any remuneration. Introduction of the handcuffs. Especially the handcuffs word are not being used in the Code of Criminal Procedure, but it is what handcuffs is being used under Section 43, subsection 3. New subsection 3 added to the Section 43 of the BNSS formally reintroduces the use of the handcuffs of a habitual or repeated offender, or accused who has committed certain offences mentioned in the subsection. If there is a heinous crime, then the handcuffs being used in this section, and handcuffs, and all the criminals being handcuffed. Section 86 of the BNSS, identification and attachment of the property. These are the new sections introduced in the BNSS, which are not available with the Code of Criminal Procedure. The process is initiated upon the request of the Superintendent of the Police or Commissioner of the Police. The request is made to the court or relevant authority of the law. After obtaining permission, the authority may reach out to a contracting state. The provision of Chapter 7, Section 111 to 124 related to the attachment and forfeiture of the property shall apply. Section 105, Recording of the search and seizure through audio, video, electronic means. We can record the search and seizure procedure because once the certain police authority has approached to the certain property, they want to search and they want to seize certain property, then it has to be recorded through audio or video. This is the new provisions introduced in the BNSS. Any property article, I think, under chapter 7, search by the police officer, section 185. These words written under section 185 subsection 2, provision related to the recording. Recording preferably by mobile. It is specifically mentioned in the section that the recording may take place through mobile phones as well. It's not mandatory that it has to be only through videography or there should be the specific prescribed camera. No. Even once you are recording through mobile, that is also valid. Because sometimes it requires that yes, there should be, you have to call the photographer and the photographer will only record all those things. No, you can also record it through mobile as well. Attachment for feature a restoration of the property. Elements during investigation, a police officer during an investigation discovers property related to the crime. The officer may apply with the approval of the superintendent of the police or commissioner of the police, the court for the attachment of the property. Section 107. Court procedure. The court order is based on the reasonable belief both before and after receiving evidence. A 14 days notice is issued, which can also be sent to any other person in possession of the property. A court may order and may issue notice, 14 days notice, which that your property is going to be attached. If you have any cause of action or any so-called notice will be issued by the court that if you have any defense, if you want to say anything, come to the court and say something. Why your property will not be attached? Should not be attached. If material facts are available, a magistrate court may pass an order for attachment. If the person does not appear, the court may issue ex parte order. In emergency, the court or magistrate may issue an order but must inform the district magistrate. Of course, once the property going to be attached, the district magistrate has to be informed that this is within your jurisdictions and it has property has to be report to the court. Further action, DM must proceed with the crime within 60 days. Whatever the property has to be attached, it has to be within 60 days, he has to proceed. If no claimant appears, the property is forfeited to the government. There will be a second hearing by the DM within 60 days if the court made an ex parte decision. If the ex parte decision has been made, then the DM will call within 60 days that if anyone wants to appear, this is the second call that he can give their appearances and give their version that this is my reason, it should not be attached, or whatever you want to say, that person can say. Section 107 contains 8 clauses potentially increasing litigation due to the extensive protections of the human rights at various stages. Restoration of the ex parte decision is not explicitly detailed as the DM has the power for a second hearing. If he will hearing and appear, then of course ex parte set aside can be order passed by the court. Person bound to conform to the lawful direction to the police. This is these all are I'm discussing. This is the new section introduced in the BNSS. Under chapter 12, the police are given authority. This chapter addresses preventive actions of the police in emergency cases, previously covered under chapter 11, section 149 to 153 of the CRPC. The inspection of the weights and measures previously under section 153 of the CRPC has been removed in the new procedure. There is no search and seizure under weights and measures under section 153. Section 153 of the Code of Civil Procedure has been removed. New section strengthens the existing powers of the police. Police has a power to search and seizure. Section 336, evidence of the public servant, experts, police officer. Change of the previous each chapter 23, section 279 to 229 of the CRPC. Now chapter 15, 25, section 307 to 336 of the BNSS. Using document as an evidence, documents prepared by the public servants, subject, experts, or medical officers can be used as an evidence at any stage of the proceedings. These all are the new sections introduced. Circumstances affecting testimony. If the relevant persons has been transferred, retired, died, cannot be found, or is otherwise unable to give testimony, which could cause delay. The court shall secure the presence of the successor of the original persons. If any original person has been transferred from one place to another person, then court can call him. And a statement may be recorded through audio, video, electronic means. Even though if they cannot come in the court physically, then his statement may be recorded either through audio or video or any other electronic modes. This is the audio video statement recording introduced in the BNSS only. Section 356, inquiry, trial or judgment in the absence of the procurement. This is the very important provisions add into this BNSS, because earlier there is no such procedure that without the appearing of the accused, the court can proceed further. No. Once the accused is not appearing, then he will be declared as proclaimed offender. His property may be attached under Section 83, but no further proceeding will go on. But here the BNSS says, yes, even though the accused is not being appearing before the court, in his or her absence, the court can proceed further and pass an order. This is the new thing came into this BNSS. That is very important, because earlier it was not possible that without appearance of the accused, the court will continue and pass the final order. No, but now it can do so under Section 356. Proceedings in the absence. The court may proceed with the trial in the absence of the proclaimed offender by recording reasons in the writing the interest of the justice. Yes, of course, the court can proceed even though he has been declared as a proclaimed offender, but the court can continue with their proceedings, but it has to be recorded in writing. He has to give the reasons that why we continue with the all those trials in the absence. Conditions for trial commencement. Trial shall not commence until 90 days have elapsed from the date of the framing of the charges. Once the charge has been framed and accused is not appearing, then the court has to wait for the 90 days. Before 90 days, they cannot start trial. 2 consecutive warrants must be issued at interval of the 30 days. There are the 2 warrants has to be issued within the interval of 30 days. Once it is issued in today, suppose if it is today is the 27th of July, then one warrant is issued, then the another warrant will be issued after 27th July means 27th August. Means there should be 30 days gaps of the 2 warrants. Consecutive warrants must be issued at interval of the 30 days. Notice of the trial must be published in the 2 newspapers, one national and one local newspaper. Notice of the trial must be published in the 2 newspapers. Of course, it has to be, because earlier there is a procedure in the CPC that once the person is not appearing before the court, then before proceeding ex parte, there is some provision that yes, you have to publish in the newspaper where the person residing or carry on the business, which are circulated in mass. So here is it was not in the Code of Criminal Procedure, but now it is introduced that notice of the trial must be published in the 2 newspapers. Earlier it was in the only procedure available with the CPC. Now it is also available with the BNSS. Relatives and friends of the accused must be informed about the commencement of the trial. His relative or friends, whoever, that he has to be informed that yes, there is a trial is commencing and accused is not appearing. Information must be affixed at the residence, home street, and on the notice board. These are information has to be affixed on the residence, home street, and on the notice board. Representation, the accused will be allowed to have an advocate. Means even though the accused is not appearing, that his presence and trial will continue in his absence through an advocate. Like as in the procedure in the CPC. Like as in the Code of Civil Procedure, there is a procedure that either the plaintiff or defendant is not required to appear in the court regularly unless and until there is an examination and cross-examination of that particular person. In the same manner, now the BNSS says the accused will be allowed to have an advocate, means he can appear through an advocate and his procedure will go on continue. If the accused doesn't have an advocate, then state shall appoint one on its own cost. Of course, there is some facility available to DLSA Delhi Legal Service Authority, wherever there is an advocate or a peer, and they can appear on behalf of the another persons, the persons who are the not in the capacity to hire the services of the advocate, then they can hire the services. They can take an advocate from the DLSA. Witnesses examination. Witnesses will be examined during the trial. Appearance of the proclaimed offender. If the proclaimed offender appears during the proceedings but before the judgment, the court will allow him to examine witnesses where his statement are recorded in his absence. Statement should be recorded if the proclaimed offender appears during the proceeding but before the judgment. The court will allow him to examine witnesses where his statement was recorded in his absence. Where if the person who was proclaimed offender is not appearing before the court, but the court trial is continued, then once he has appeared, then it is a discretionary power vested with the court that the honorable court may allow, may not allow the persons to cross-examine that witnesses which was examined in the absence of that accused person. A statement should be recorded by audio, visual means, preferably by cell phone, and record should be kept as per the court order. Now, all the proceedings is going on before coming into the BNSS also, because certain times in some statements in being recorded through video conferencing, and after signing the documents, they can those sent to those documents through email, electronic modes, email, and that is valid. So although the witnesses can be examined through audio video conferencing. Section 356, trial continuation. If the accused appears, is arrested, or is brought in any stage of the trial, including during judgment, it shall not prevent the continuation of the trial. Of course, once he is not appearing and trial is going to continue, and thereafter he is appeared, then whatever is proceeding is going on, that is the valid proceedings. That cannot be you cannot say that no, I was not appearing, therefore this proceeding is not valid. No. Appeal conditions, there will be no appeal unless the proclaimed offender appears. Unless and until the PO person is appeared, there is no appeal. The time limit for appeal is 3 years. There is a time limit that once the person is a proclaimed offender and there is an order has been passed against him, final order judgment has been passed, then the time limit for appeal is 3 years, but he has to appear before the court first. The state can apply this provision to the proclaimed accused under section 84. All those conditions are specifically deals with the persons who are the proclaimed offenders. Witnesses protection scheme. Every state shall prepare and notify a witness protection scheme. There is a new section 398 that you may heard sometimes that witness as being murdered or witness are being pressurized. All those things that for the protection of those witnesses, there is a new section introduced 398. Every state shall prepare and notify a witness protection scheme. The scheme aims to ensure the protection of witness. Similar scheme exists in Canada and European countries because there are the certain schemes came into this BNS. It may be taken from the another countries as well. India already prepared a witness protection scheme in 2018. 472 mercy petitions in death sentence. This is also a new section introduced in the BNSS. Applies only to those convicted of a death sentence. The convicted persons, their legal heirs, or any other relatives as the locus standi to file a mercy petition. The petition can be filed before the President of India under Article 72 or the Governor of the state under Article 161. The petition must be filed within 30 days from the date the jail superintendent informs the convicted persons about the dismissal of the SLP, appeal or review, or the confirmation of the death sentence by the High Court. 472. Process requires filing of the mercy petition with the Governor first, and then with the President of India within 60 days of the Governor's rejections or disposal. Every person convicted and sentenced to death has the right to file a mercy petitions within 60 days after receiving information. Upon receiving the mercy petitions, the President of India will seek comments from the state government. The President must dispose of the case within 60 days. In cases multiple convicted persons collectively in the interest of justice. Section 530. trial and proceeding to be held in electronic mode. This is the also new sections. All trials, inquiries and proceedings, including issuing, serving and executing summons and warrants, examination of the complaints and witnesses. Even the summons served through WhatsApp, it can be served through email. All trials, inquiries and proceedings, including issuing, serving and executing summons and warrants, trial and proceeding to be held in electronic mode. All trials, inquiries and proceedings, including issuing, service and executing summons and warrants, examination of the complaints and witnesses, recording of evidence in inquiry and trials, or appellate or any other proceedings may be conducted in electronic mode, utilizing electronic communications and audio video electronic means. This is the section 530 introduced specifically in the BNSS, the use of the audio video electronic modes. There are the total 531 sections in the BNSS. So these all are the new section introduced. If thereafter we will go for the key changes in the BNSS. Before going to key changes in the BNSS, if any query, if any discussions, then certainly we will have that discussions. Otherwise, you will go ahead. So please, if there is a query, if there is some discussions, please. Yes, friends. Is there a question and is there any query to be discussed? Please. Am I audible to all of you?
Yes.
Because we have discussed, there are the certain new sections introduced in the BNSS which were not available in the Code of Criminal Procedure. And now we will discuss what are the changes take place, what is available in the Code of Criminal Procedure, and there are the new section introduced in BNSS, then what is the changes in that? Because we have we have discussed what have been new introduced. Is there any query? Then otherwise you can go ahead. Yes, anyone, please. All are listening to me?
Yes, sir. We are listening.
Is there any query? Otherwise, you can go ahead. Yes, please.
Yes, sir. Please go ahead.
Thank you. Now we will discuss there are the certain key changes. We have already discussed key changes in the BNSS. There are the removal of the certain archaic terms like the assistant session judge has been removed. Pleader has been removed by the word advocate. Now there is in the entire country, there is a similar, you can say, designations of the honorable courts. Earlier in the metropolitan cities, like there is a metropolitan magistrate. And in the states where there is no metropolitan city, there is a judicial magistrate first class. So now the government has decided to have a uniform designation to all the judges, irrespective of the union territory or the states. So there will be 4 kinds of the judges now: judicial magistrate of the second class, judicial magistrate of the first class, judicial magistrate of the second class. Earlier it was the metropolitan magistrate, now it is a judicial magistrate of the second class, and chief judicial magistrate or additional chief judicial magistrate cover under the judicial magistrate of the first class, and session judge includes additional session judge and executive magistrate. These are the only the 4 judges hierarchy, especially in the lower courts we are talking about. The judicial magistrate of second class, judicial magistrate of the first class, session judge includes additional session judge. There is no metropolitan magistrate now. after the introduction of the BNSS. Removal of archaic terms, removal of metropolitan areas, a metropolitan magistrate has been removed. Judicial magistrate will be uniformly referred to as the godless of the city. Outdated provision, section 153 of the CRPC, that has been already removed. We have already discussed. Zero FIR. The word zero is not being specifically used, but yes, during section 173 BNSS, earlier it was 154 CRPC, by adding the words irrespective of the area where the offense is committed. These new words have been added, irrespective of the area where the offense is committed. The scope is respond to the laws and FIR. What is the zero FIR basically concept is that once the offense is committed in another area where we are not residing, then for the speedy lodging of the FIR, you can go to the concerned police station and immediately lodge an FIR against the accused persons, and that FIR has been transferred later on to where the person resides. So this is the concept of the zero FIR. Probably my learned friends are aware about the zero FIR or not? Yes, please.
So sorry for interfere. This is Dharminder Sharma. Very good afternoon. Can you repeat? Previous slide? Can you explain previous slide?
Which slide?
This one.
Changes in magistrate terms.
Right.
Metropolitan, because there is in metropolitan area, there is a metropolitan magistrate. Suppose in Delhi is a metropolitan city. And once there is a metropolitan city, then here is a metropolitan magistrate. But this metropolitan magistrate is no more metropolitan magistrate. Metropolitan magistrate word have been removed in the BNSS. They all are into the category of the judicial magistrate first class or judicial magistrate second class. There is no metropolitan magistrate as of now once this BNSS has been introduced.
All right. Thank you for explaining it.
Thank you. All my learned friends are aware from the zero FIR or not? Yes, please. Anyone? Please respond.
Yes, sir. Yes, sir.
All of you are aware about zero FIR?
Yes, sir. Yes, sir.
Yes, sir.
So, respective of territorial jurisdiction, FIR can be registered at first instance. It is like that.
The zero FIR, I think, according to me, is filed in any police station regarding the place where they committed the crime or jurisdiction in a police station.
Basically, zero FIR concept is once, suppose I'm giving an example. Suppose you are the resident of Delhi and you have gone to Gurgaon with some work or for any purpose. But if some offense has been committed in the Gurgaon, then you can immediately register an FIR of the concerned police stations where the offense has been committed. And that offense, once the FIR has been registered there, then that FIR will be transferred where you reside in Delhi. Then the Delhi police will take cognizance of that FIR. This is called zero FIR because FIR has been registered in the Gurgaon, but it has to be taken cognizance by the Delhi police where you reside, and further it will go ahead. So this is called zero FIR because where you will not wait that you will come in Delhi, then you will register an FIR. Where the offense has been committed, you will immediately register an FIR in that particular place. It is meant to help victim of the serious crime, especially women and children, because this is especially concept came especially there is an offense committed against the women or the children to lodge a complaint quickly and conveniently without having to go from one police station to the another police station. It is transferred to the relevant police stations where the offense has taken place or where the investigation has to be conducted. Later on, it has to be transferred. Under section 160 of CRPC, there was no provision for the witnesses above 60 years of the age to record a statement to police in a place other than the place in which such a person resides. Same is the protection to the mentally or the physically disabled and persons of the acute illness. Earlier, there was a provision that 65, if the age was the 65 years of the age. If the person is above the 65 years of the age, then they can record their statement where he resides, he or she resides. But now it has been reduced from 65 to 60 years. The persons of the 60 years of the age, that if anything recorded, that they can record in that particular police station where he or she resides. This is the protection available to the senior citizens or the infirm persons. Under section 160 CRPC, there was no provision for the witnesses above 60 years of the age to record a statement to police in a place other than the place in which such a person resides. Same is the protection to the mentally or physically disabled persons of acute illness. The above is in protection with reference to the protections of the human rights. So now this protection is available to the persons who are 60 years of the age or the not very capable persons. Proclaimed offender, section 82, subsection 4 of the CRPC, limited proclaimed offender status to 19 specific IPC offenses. Once you are talking about section 82, subsection 4 of the CRPC, there are the certain sections are mentioned. But in the BNSS, this is the change. Section 84 of the BNSS, 82 CRPC and 84 of the BNSS of the same proclaimed offender deals with the proclaimed offender. Removes this restricted list. Now anyone accused of an offense punishable by more than 10 years of imprisonment or other special offenses can be declared a proclaimed offenses. There are certain restrictions on the 82 subsection 4. There are the certain sections was mentioned, but here all those sections have been removed and simply written that if there is an offense punishable by more than 10 years of imprisonment or other special offenses can be declared as a proclaimed offender. New section 356 provides detailed procedure for the trials inquiry in the absence of the proclaimed offender. What is the trials and inquiry? We have already discussed. That is the new section 356. Proceeding safeguards and changes. Safeguards for the vulnerable individuals. Section 35, subsection 1. No arrest shall be made without prior permission of an officer not below the rank of the Deputy Superintendent of Police in the case of an offense which is punishable for imprisonment of less than 3 years and such person is infirm or is above 60 years of the age. No arrest. There are the certain safeguards are provided that no arrest shall be made without prior permission of the officer not below the rank of the DCP. Once you want to arrest a person above 60 years of the age, then you have to take a permission of the DCP, Deputy Superintendent of DSP or DCP or whatever designation is. In the case offense which is punishable with imprisonment of less than 3 years and such person is infirm or is above 60 years. If there is such person is infirm means is not very well and sound. There is a certain disability or he is not well, means or it he may be sick, infirm. Then and above 60 years and offense is a punishable offense less than 3 years, then you have to take a permission before prior permissions to arrest that persons. There is a safeguards provided in the BNSS. Section 190 subsection 1 of the BNSS provision subsection 1 provides immunity to the male members under the age of the 15 years or above the age of 60 years or a woman or a mentally or physically disabled persons or persons with acute illness shall not be required to attend at place other than the place where such persons reside. However, they can attend the police station willingly. If the persons of the age below the 18 years, under the age of 18 years, or age of the 60 years, or above the age of the 60 years, then illness shall not be required to attend at place other than the place where such persons say. There is a immunity provided, safeguards provided to the persons who are under the age of 15 years or above the age of 60 years. Then whatever you want to record, then he will record the statement only on the police station where he resides. Suppose I am residing in the Patel Nagar and he is asking that you should come to the Malvi Nagar to record your statement, then I can simply deny, no, I will not go there. I will just go to the police station Patel Nagar and I will record my statement. Unless and until you want to voluntarily go to the recorded your statement. So this is the immunity, this is the protections, this is the safeguards provided to the persons who are below the age of 15 years or above the age of 60 years. Forensic procedures, section 176 of the BNSS 1, new subsection 3 mandates forensic teams visits to the crime scene and videography for the crimes punishable over 7 years. If the offense is more than punishable under more than 7 years, then the forensic team will go there and videograph all those things. Complaint cases 272 of the BNSS, complainants can be given 30 days to appear before discharging the accused. 360 of the BNSS, courts must hear victims before allowing withdrawal from the prosecutions. These all are the changes take place. Statements recording safeguards, added safeguards for recording statements, including female judges for women's statement and magistrate for the serious offences. Arrest procedures, new subsection 3 is added regarding the handcuffs of the habitual or repeated offenders or accused who has committed certain offences mentioned in the subsection. It is already been discussed. 82 is already also been discussed. Arrest for the appearance, 190 subsection 1 BNSS, new provision to add in subsection 1 regarding taking security from accused not in custody for the magistrate and mandate the magistrate to accept the same. Mandates state governments to establish witness protection scheme. There are the certain, this is also the new thing, the witness protection scheme. Interim guidelines, BNSS has already been discussed. Section 1, investigation process updates. Section 173, subsection 2, CRPC extends the requirement of the complete investigation within 2 months for offences under the protection of the children from sexual offence, POCSO, especially under section so and so. Extend the requirement to complete the investigation within 2 months for offences under the protection of the children from sexual POCSO. We have to complete the investigation within 2 months. Reports to magistrate can be forwarded electronically. Section 193, subsection 3, reports can be forwarded electronically. Police must inform informants, victims about investigation process within 90 days, including electronically. It means all those information can be sent through electronic mode. Section 223 of the BNSS, section 200 of the CRPC. This is the one very important change takes place in this section. Accused must be heard before magistrate take cognizance of the complaints. Whatever, this is a very important, you have to listen very carefully that earlier, once you are filing a complaint, criminal complaint under section 200 CRPC, then the court recorded the statement of the complainant and take cognizance and serve summons to the accused. But now this is a change in the BNSS under section 223 of the BNSS. This is the new subsection 2 of section 2023. A magistrate cannot take cognizance of the complaint against a public servant for offences alleged during the discharge of the official duties unless the public servant is given a chance to present their side of the situations leading to the alleged incident. Magistrate will not take cognizance unless and until he has given an opportunity to be heard. A report detailing the facts and circumstances of the incident is received from the superior officer of the public servant. There are the certain conditions have been imposed that unless and until the magistrate provide an opportunity to the accused of being heard, they cannot take cognizance and summons cannot be issued. This is the new takes place under section 200 CRPC of the criminal procedure, 223 of the BNSS. Please, progressive safeguards and changes. Section 232 of the BNSS, section 209 of the CRC, first provision mandates that the proceeding under this section must be completed within 90 days from the date of taking cognizance. Magistrate may extend this period up to maximum of the 180 days with reasons to be recorded in. There are the certain time bound process. Second provision specifies that any application filed by the accused, the victims are authorized persons in cases tried by the court of the session must be forwarded to the court of the session along with the committal of the case. Section 207 CRPC, Section 230 of the BNSS, police reports and documents must be provided to victims or their advocates. Progressive safeguards and changes 283 BNSS power to try summary. Subsection 2 is newly added with a provision to it for the trial of the offences punishable with the 3 or less than 3 years in a summary way. There is a summary trial procedure. This is a time-bound process. Earlier it was not a time-bound process. Time is specified, but it is now the time is specified. Provided that no appeal shall lie against the decision of a magistrate to try a case in a summary way under this subsection. Plea bargaining adjustment, Section 293, Clause C and D, make changes to require the court to show leniency towards first-time offenders who opt for the plea bargaining. What is the plea bargaining? Anyone else, please? Yes. Am I audible or not?
Yes,
No
sir. Yes,
response.
sir. You are audible.
What is the plea bargaining? Yes, Ms. Achal. Yes, Ms. Achal. What is plea bargaining? Am I audible? Anyone, please?
Yes, sir, you are audible.
Then why
Yes, sir. Yes,
you are
sir.
not
Yes, sir.
receiving any response from anyone? What is the plea bargaining?
Sir, basically plea bargaining is कि the person is admitting that he has committed this crime so that the court can give a lesser amount of punishment for his offense.
Yes, yes. Thank you. Plea bargaining adjustment, Section 293, Clause C and D, make changes to require the court to show leniency towards the first-time offenders who opt for the plea bargaining. Once they have admitted their offense, then there is some lenient may be taken by the court that certain offense, certain amount may be imposed, and he may be released from that offense. He may be acquitted. There may be sentenced to 1/4 of the minimum punishment instead of half, and 1/9 instead of the 1/4, respectively. Proceeding forensic science in the investigation, Section 311A of the CRPC, Section 349 of the BNSS expanded to include fingerprints and voice samples, in addition to the specimen signature and handwriting samples. This is the new concept of the fingerprints and voice samples under this BNSS. Then 330 of the BNSS, Section 294 CRPC, time limit for the document verification. A 30 days time limit is set for the party to accept or deny the genuineness of the document. However, the court can extend this time. There is the time-bound process of the document verification. 30 days time limit is set for the party to accept or deny the genuineness of the documents. However, the court can extend this time. Expert involvement, experts are to be called only if the document's authenticity is disputed by any party during the trial. Electronic and digital alternatives for existing process. 176 of Section 1 of BNSS corresponding to Section 1. So police statement during investigation can be recorded electronically. Electronic and digital alternatives for the existing processes. Although electronic modes can be used in this new BNSS. Electronic and digital alternatives are existing processes. Now there are the certain points to be discussed with the controversial changes. 107 of the BNSS grant police the power to seize and forfeit property suspected to be involved in the criminal activity. This provision requires careful judicial interpretation What these powers are vested with the police to seize and forfeit the property of the suspected persons. Of course, once the powers are vested with the police, then it may be misused. So this should be the very carefully, the court should intervene while the police is doing such thing. So this is the change, of course, but although there are the certain powers are vested with the police officials, and it is always that once the power has been vested with the police, they can misuse it. So this is the controversial change we are discussing it now. 144 ACRPC prohibiting arms in the processions. Non-notifying section 144A of the CRPC, which could prevent weapons in the public processions, is not included in the BNSS. This is 144A CRPC prohibiting arms in the processions. Once you are in the doing certain processions, then the arms are prohibited. Non-notified section 144A of the CRPC, which could prevent weapons in the public processes, is not included. This is not included in the BNSS. Means there is no restrictions, means there is no specific restrictions, means no restrictions. This omission could allow for the potential violence during the public events. This is the controversial changes. This is not included. Preliminary inquiry for the cognizable cases. In new section 3, in section 173 of the BNSS, reintroduced a preliminary inquiries for offences with imprisonment terms of the 3. If there is a offence related with the 3 to 7 years, then the police has a power to go for the preliminary investigation and inquiry up to 14 days. They can first inquire, then he will register FIR. Then this is also a power that has been vested with the police that can be misused. This could undermine the clarity provided by the Lalita Kumari verdict, which limited preliminary inquiry to the specific situations. But in this section introduced 173 subsection 3, that there should be some preliminary inquiry, then FIR can be registered. This is also one of the controversial change. House arrest. Earlier, there is a provision for the house arrest. New provision section 177 subsection 5 of the BNSS specified that detention can only occur in the police stations, prisons, or government declared places, and thus doesn't include house arrest. Earlier, there is a provision for the house arrest, but in under section BNSS, there is no such provision of the house arrest. Specifically, the 187 subsection 5 of the BNSS specifies that detention can only occur in the police stations, prisons, or the government declared places. No house arrest. And controversial changes, another controversial changes, greater use of the forensic science. A new provision added to section 349 of the BNSS corresponding section 31A of CRPC allowed magistrate to request specimens from any persons even without arrest. Means the court has a power to ask for the specimen signature of the any persons, the person who is not being arrested, means any third persons, the court has a power now to ask for the specimen signatures. Earlier it was that the person who are arrested, that only bound to give the specimen signatures. Now the court can ask for the anyone, whether it is arrested, accused, not accused, doesn't make any difference. New provision added to section 349 of the BNSS allows magistrate to request a specimen from any persons even without arrest. Earlier, this was restricted to individuals already arrested. This change raises concerns about privacy and the potential misuse. And last but not least, is CRPC obsolete now? Yes, please come again. What it means? Any one of you? Please respond. Is CRPC absolute now? Yes, please.
No, sir.
No, sir.
What is its consequences? Still it is in force? Is CRPC obsolete now or still it is in force? What do you
Still
think?
in force, sir.
How? Because the BNSS, it is replaced by the BNSS from 1st July.
सर बट प्रीवियस केसेस हैं वो तो सीआरपीसी से ही डेल्ट होंगे ना.
Acha ji, very good, very good. Yes, it is correct. Is CRPC absolute now? No. Section 531 of the BNSS provides that if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry, or investigation pending, then such appeal, application, trial, inquiry, or investigation shall be disposed of, continue held, or made as the case may be in accordance with the provision of the CRPC, as in force immediately before such commencement, as if this Sanhita has not come into the force. The CRPC is still very much in the use. Of course, the CRPC is now not absolutely obsolete. It is still in force, but force only up to that it is applicable, and the cases before the 1st July 2024 that will be dealt by the CRPC, and any offense after 1st July 2024 that will be dealt by the BNSS. Procedure will be applicable of the BNSS. Earlier it will be applicable CRPC. Now, thank you. Thanks for all your learned friends to have a patience listening. Even though if you have any doubt, any query, then you can get in touch with our mobile number, and email ID is displaying here. And certainly now we will have a question and answer sessions. Yes, if anyone have any questions, doubts, then certainly we will discuss it. Yes, friends. Anyone want to discuss anything? Please, you are most welcome.
Sir, what is your opinion whether the implementation of this new act won't it create the confusion in the implementation of old and new law simultaneously?
No, there is no confusion, nothing else, no confusion at all. The
Like
reason
there
behind,
is
yes.
a change in session which were in practice of the advocates who were practicing regularly. Now
Yes,
they have to practice both old law and new law simultaneously. So
yes.
won't it lead to confusion and chaos? Like
No, there is no confusion, no chaos. Because the Consumer Protection Act 1986 is still in force, and Consumer Protection Act 2019. Both are going simultaneously. Because the cases which were dealt by the Consumer Protection Act 1986, that will be continued with the 1986, and now the new cases came after 2019, from the 20 July 2019, that will be dealt by the Consumer Protection Act 2019. So in the same manner here, the new cases came after 1st of July 2024, or from the day of the 1st July 2024, that will be dealt by the BNSS, and the cases which are already continued before 1st July 2024, that will be dealt by the CRPC. The procedure, this is the CRPC procedure, BNSS is also the procedure. The procedure, what the procedure has to be followed. There is no confusion, no question, nothing else. But only the cutoff date. We have to remember the cutoff date. The cutoff date is 1st July 2024. If the procedure will be followed after from 1st July 2024 BNSS, and before 1st July 2024, the procedure will be CRPC. It's very clear.
thank you, sir.
Yes, Mr. Asit Singh, if you want to say something. Asit Singh, is there in chat?
No, sir.
Is there any question? Everyone, please share.
सर सेशन बहुत ही वंडरफुल था, और एक डाउट क्लियर हो गया इस सेशन से। मैं बहुत दिन से ये मैं फेस कर रहा था, फेस क्या छोटी सी प्रॉब्लम है, बट शेयर करना चाहूंगा। मैं कोर्ट जाता था, मैं देखता था कि मेट्रोपॉलिटन मजिस्ट्रेट जुडिशियल मजिस्ट्रेट हो गए। मैं कई लोगों से पूछा, वकील साहब से भी पूछा कि सर ये क्या चक्कर है, सारे मेट्रोपॉलिटन जुडिशियल मजिस्ट्रेट क्यों हो रहे हैं, लेकिन किसी को नहीं पता। मैंने रीडर साहब से भी पूछा कि क्या दिक्कत हो भाई कि ये मेट्रोपॉलिटन मजिस्ट्रेट जुडिशियल मजिस्ट्रेट हो गए, ये सर आज क्लियर हो गया कि सीआरपीसी की वजह से सारे एमएम अब जीएम ही कहलाएंगे।
जी 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 जी, एमएम का कंसेप्ट खत्म हो गया।
जी
BNS 1 जुलाई 2024 से मेट्रोपॉलिटन मजिस्ट्रेट साहब खत्म हो गए अब।
हाँ हाँ, ये
हाँ।
थोड़ा सा
खत्म हो गया।
खत्म इन द सेंस नेम चेंज हो गया।
हाँ मतलब वो डेजिग्नेशन खत्म हो गई ना। देयर इज नो मेट्रोपॉलिटन मजिस्ट्रेट इन मेट्रोपॉलिटन सिटीज फ्रॉम 1 जुलाई 2024।
जी सर।
यस, एनीवन प्लीज। और भी हमारे कुछ साथी अगर कुछ पूछना चाहें तो certainly they can have a query. Whatever I have the knowledge, certainly I will try to my best to clarify all those issues. Yes, Dharmender ji, बोलिए।
Hi sir, how will the new provision in BNNS 2023 impact the provision for the arrest, bail, and trial? Are there any anticipatory bail improvement or fairness?
दोबारा पूछिए, क्या पूछा आपने?
सर जो BNSS के 2023 के प्रावधान थे गिरफ्तारी के, जमानत के या मुकदमे के, उनकी प्रक्रिया में
प्रावधान थे
कैसे
नहीं, प्रावधान हैं। 2023 BNSS के प्रावधान हैं, थे नहीं हैं।
हाँ जी हाँ जी। तो उसमें अभी पिक्चर में क्या सुधार, नया क्या चेंजेस आया है 2024 में, जैसे पहले CRPC में डिफरेंट थे?
सुधार जो चेंजेस आए, कुछ तो नए चेंजेस हमने जो आपको बताए कि जैसे प्रॉपर्टी का सर्च एंड सीजर का था, इन्वेस्टिगेशन इंक्वायरी का था, जो समन इशू हो जाएंगे, बेल की पहले डिफिनीशन नहीं दी हुई थी, बेल बॉन्ड की डिफिनीशन नहीं दी हुई थी, ये सब नए चेंजेस आए हुए हैं। लेकिन अगर आप 438 या एंटीसिपेटरी बेल में अगर पूछें तो बेल की प्रोविजन ऑलमोस्ट सेम ही है, क्योंकि सेक्शन बदल गया है। लेकिन उसमें पहले 438 था, इसमें अभी सेक्शन बदल गया है। तो अब आपकी जो बेल एप्लीकेशन लगेगी 438 CRPC में आज की डेट में नहीं लगेगी। उसका जो कॉरस्पॉन्डिंग सेक्शन हैगा, उस सेक्शन में आपको जो है आप एंटीसिपेटरी बेल लगानी पड़ेगी।
सर सीआरपीसी तो रेट्रोएक्टिव है?
ना जी, रेट्रोएक्टिव नहीं है जी, प्रोस्पेक्टिव ओनली।
सर जो ऑफेंस पहले कमिट हुआ है, लेकिन अगर एफआईआर जो भी हम रजिस्टर करेंगे या जो भी प्रोसीजर होगा, कोर्ट में कंप्लेंट फाइल करते हैं, देन हम तो उस पे BNSS पे ही फाइल करेंगे एज पर द प्रोसीजर ऑफ द BNSS।
देखिए ऐसा है ना कि जैसे FIR अगर आज की डेट में होती है,
ऑफेंस सर पहले हुआ है,
पहले हुआ है, लेकिन FIR आज
जी
की डेट में होगी तो उसके प्रोसीजर आज के ही लागू होंगे ना। जैसे मान लीजिए
हाँ
कोई कहता
सीआरपीसी
है कि मेरे साथ 2 साल पहले कोई ऐसी घटना हो गई,
जी
लेकिन जो है अगर FIR अगर आज की डेट में 26 जुलाई या 27 जुलाई को FIR होती है, तो 27 जुलाई की जो FIR होगी वो BNSS से ही होगी।
जी 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 1 जुलाई को भी, 1 जुलाई से भी होगी रात के 12 तो भी।
1 जुलाई से, क्योंकि पहले FIR नहीं हुई तो उस पर जो है CRPC एप्लीकेबल नहीं है। लेकिन आज की डेट में अगर FIR हो रही है
जी सर,
तो वो तो एप्लीकेबल तो यही होगा ना आज की डेट वाला। तो क्योंकि एंटीसिपेटरी बेल लगी, FIR अगर 1 जुलाई 2024 पे हो रही है तो
जी
वो उस हिसाब से एप्लीकेबल होगा।
जी
438
Hello, sir.
जी।
Sir, I have another question.
438 का जो है ना 482 में अब होगा। जी जी प्लीज बोलिए।
सर
Yes,
जो वो ट्रायल इन एब्सेंशिया 356 जो आपने बताया था,
जी
तो वो आपके हिसाब से अच्छा सेक्शन है या लाइक प्रोन टू मिसयूज होगा फिर वो?
नहीं देखिए ऐसा था ना कि जैसे ट्रायल पहले क्या होता था, जब एक्यूज को अपीयरेंस मस्ट था, अगर एक्यूज अपीयर नहीं होता है तो उसके खिलाफ 82 की प्रोसीडिंग होकर के फाइल कंस्टांटिव रिकॉर्ड में चली जाती थी, उनको फिर सजा नहीं मिल पाती थी। लेकिन ये BNSS में नया प्रोविजन जो लाया गया है हमारे ख्याल से सही है इसलिए सही है कि अगर एक्यूज नहीं भी है तो भी उसको अगर किसी हीनस क्राइम में है तो उसको सजा मिलेगी। और जब भी वो उसको अगर मान लीजिए 7 साल 10 साल की अगर सजा कोर्ट ने ग्रांट कर दी, जब भी वो अरेस्ट होगा या जब भी पकड़ा जाएगा तो वो उससे सजा उस पर अप्लीकेबल होगी, क्योंकि फिर दोबारा से ट्रायल नहीं चलेगा उसके अगेंस्ट। और 82 प्रोसीडिंग पहले क्या होता था, जब फाइल कंसाइंड टू रिकॉर्ड हो जाती थी, पीओ डिक्लेयर हो जाता था, तो उसको कोई सजा मिलती ही नहीं थी। फिर वो जब 82 में अगर अरेस्ट हो गया तब फिर जो है फिर से ट्रायल उसके अगेंस्ट शुरू होता था। मतलब एक बार फाइल कंसाइंड टू रिकॉर्ड रूम चली गई, फिर 2 4 5 साल वो गायब रहे, फिर उसके बाद उनका ट्रायल शुरू होगा। तो ये गलत, मतलब ये मतलब उतना बढ़िया नहीं था। मतलब जो हैबिचुअल ऑफेंडर्स हैं कई बार इसका जो मिसयूज करते थे, लेकिन अब आप आए चाहे ना आए, आप एडवोकेट के थ्रू भी आए तो भी आपका केस चलेगा ही चलेगा और आपको सजा मिलेगी। भाई एक्यूज के लिए हो सकता है ठीक नहीं, लेकिन जनरल पब्लिक जिसने जो कोर्ट से जो है अपनी मांगने गया है रिलीफ, उसके लिए तो अच्छा है।
Oh, yes, sir. Thank you.
हाँ जी जी। यस, आप भी कोई हमारे सज्जन साथी? हमारे सभी सभी साथी जो है अपना ईमेल आईडी जो है इसमें अपना भेज दें ग्रुप पे, और अपना जो है क्या कहते हैं मोबाइल नंबर भी शेयर कर दें, जिससे हम सभी साथियों को जो है, जो भी हमारे साथी आज अटेंड किए हैं, उनको हम एक सर्टिफिकेट इशू कर पाएँ कि हमारे सभी साथियों ने 1 घंटे का समय हमें जो है बहुमूल्य और कीमती समय दिया। और मैं प्रयास करता हूँ कि भाई अगर 1 घंटे समय अगर किसी साथी ने हमारे दिया है तो वो बहुमूल्य समय होता है, और उससे कुछ न कुछ जरूर सीख के यहाँ से जाएं।
यस सर।
और हमारे जितने भी साथी यहाँ पे हैं, अगर उसमें से भी कोई साथी अगर किसी सब्जेक्ट मैटर पे जो है बोलना चाहता है तो दे आर मोस्ट वेलकम। दिस इज द प्लेटफॉर्म प्रोवाइडेड टू ऑल द लर्नड फ्रेंड्स, स्पेशली द इन्वेस्टर्स who want to share their views। क्योंकि कई बार जो है बोलने में कई लोगों को बड़ी तकलीफ होती है, और कई लोग बोलना चाहते हैं लेकिन कई बार उन्हें प्लेटफॉर्म नहीं मिल पाता। दिस इज द प्लेटफॉर्म अवेलेबल टू ऑल ऑफ यू, यू आर मोस्ट वेलकम। आप आकर के अगर बोलना चाहते हैं तो जरूर बोलिए, क्योंकि रिक्वेस्ट यही रहेगी थोड़ा तैयारी करके आइए। और ऑल जो इन्फॉर्मेशन आप पब्लिक के साथ शेयर करें, सभी के साथ शेयर करें, वो आप टू द मार्क और उसकी ऑथेंटिसिटी चेक करके ही लोगों को डिलीवर करें। मेरी रिक्वेस्ट के लिए यू आर ऑल मोस्ट वेलकम। इफ देयर इज नो
सर
फर्दर
लिटिल बिट
क्वेश्चन।
लाउड प्लीज, आवाज नहीं आ रही है।
हाँ, if there is any further question then we will go ahead, otherwise we will close this because time is running 15 minutes more than the one an hour. So is there any questions? Otherwise you will close it.
Is
Please, we can close it now with the permission. हाँ, नहीं कुछ तो बोलिए।
Shall I go with the vote of thanks?
Yes, yes, please.
Okay. I stand here today as proud and grateful to express my heartfelt thanks to all those who have made this session possible. I would like to start by thanking Vidya Vijay Foundation, who have always been supportive and encouraged us to strive for excellence. I would also like to extend my gratitude to Dr. Nityanand Singh, who have been our guiding lights, imparting wisdom and knowledge to us and nurturing our talents. Their unwavering support has been instrumental in
there
growth
is a
and development. I have taken time
internet
out of
error.
their busy schedules to grace this occasion with their presence. Your presence has added an extra spark to this session and made it even more special. I request everyone to share their email IDs and names for the certificates.
बहुत बहुत धन्यवाद सभी साथियों का।
सर
नमस्कार। जी बोलिए।
सर ये सर्टिफिकेट आप कोरियर करेंगे या खुद ही रिसीव करना होगा?
ईमेल भेज देंगे आपको, आप ईमेल दे दीजिए। डिजिटली साइन कॉपी रहेगी, क्योंकि डिजिटली सब कुछ वैलिड हो गया है थ्रू द BNSS।
यस सर।
तो आपको डिजिटली जो है आपके ईमेल आईडी पे भेज दिया जाएगा, आपको मिल
थैंक
जाएगा।
यू।
सभी
थैंक यू,
को बहुत बहुत धन्यवाद, नमस्कार। आप लोगों ने अपना
Thank-
दिया। आई एम
बहुत बहुत शुक्रिया सर, दिस सेशन वाज वेरी वंडरफुल।
थैंक यू टू ऑल ऑफ यू।
आ गया भाई वो।